Hello, welcome back to Marriage Practice and Procedure. This is video 5, and we're going to be talking about a very short lesson, lesson 10, then a little bit longer lesson, lesson 11 today. But actually, there are 3 lessons that go together pretty closely. Lessons 10, 11, and 12. And I'll tell you why in just a moment. What we're going to begin with is kind of just a very quick review of Canon Law 2 on consent. What we're talking about now are problems with consent in all of these next 3 lessons, 10, 11, and 12. But we're only talking about some specific problems of consent. We're especially concerned with lack of due reason, lack of due discretion, and lack of due competence. So we'll get to that in a moment, and then just about 2 or 3 minutes we'll talk about why lessons 10 through 12 are kind of grouped together so closely. Okay, but let's start by reviewing the nature of matrimonial consent. This a good place to start here would be Woodall at 386 from Canon Law 2. You also can find this in Whewell's The Pastoral Companion at 255 to 259. So just a few basic principles about consent. These should all sound pretty familiar. 1, consent is given at present. When you exchange consent, you are consenting now. You're not saying, I will take you in the future. So it's not engagement. Marriage is different from engagement. Engagement, you're making a sort of a future promise, or you're promising to get married. But with consent, it's given now. I'm giving myself to you now. You're giving yourself to me now. It's at present. Also, the consent must be particular. It's not just, boy, I want to get married. I want to be married by the time I'm 30 or whatever. No, it has to be particular. I give myself to this woman. This woman gives herself to me. It's to a specific person. And also what consent is, it has to be for the purpose of establishing a marriage. It's not just attraction, not just wanting to have children, but specifically to establish a marriage. And consent cannot be supplied by any human power. That's Canon 1057, Section 1. So we've talked in a whole lot of this class about, if there's a problem with form, we can address that in some way. If there's a problem with an impediment, we can address that in some way, and we may be able to validate or sanate the marriage. If there's a problem with consent, though, there really isn't anything to validate. If people really didn't consent or were not able to consent, the church cannot sanate that. The church cannot supply the consent that the spouses have failed to give. The consent also has to be manifested. It has to be manifested. That means it has to be done in some outward way. That's why we don't just think, oh, I love this person. It's not just think about how much you love this person. It's no, say I do. You express your consent. You manifest your consent so that it's public, etc. And consent is an act of the will. It's not simply a feeling, even a feeling of love. It's an actual act of the will. Whewell says this at 256. Matrimonial consent is an act of the will. Key to understanding this consent is the distinction between the human faculties of intellect and will. The will judges, intends, decides, chooses, obeys, etc. The intellect thinks, believes, reasons, opines, deliberates, understands, etc. So we're going to be concerned both with intellect and will. The code is going to presume that if you express your consent, then you are being truthful, that your expression of consent, it manifests what you're actually what your actual interior disposition is. So if you say I consent, I accept this, I accept this person for the rest of my life, that you're being honest. If you say it, we're going to assume that you're being honest, and that's your real internal disposition as well. We have these important principles that we need to talk about with consent. The ones we've just talked about, that it's an act of the will, must be manifested, etc. But we have to be careful about not placing too many qualifiers on it. We can't make the burden or the standard for valid consent so high that most people could not attain it. So it has to be something that a regular person, not an expert on marriage, not an expert on theology of the body, but a regular person would be able to do, that they would be able to manifest and to really have this consent and express it. Okay, some key canons. Canon 1057, that is the canon on consent. Also what we just talked about, the presumption of consent. If you express consent, we're going to presume that that represents your interior disposition as well. And also very important canon. Oh, by the way, that last canon about interior and exterior consent being congruent, that's Canon 1101. Another very important canon is Canon 1060, and that says marriage enjoys the favor of the law, the favor or favore juris. So what that means is that if there's a marriage, then we're going to assume it's valid. What has to be proven, validity does not have to be proven, invalidity has to be proven. If you were married and you went through the proper form and did what looks like a marriage, our presumption is going to be that's a valid marriage. Marriage enjoys the favor of the law. So if we look at the marriage and we can't reach a conclusion, or there's evidence on both sides, we're going to say that the marriage is valid. The thing that has to be proven is not validity, it's the invalidity that has to be proven. Or we could say the petitioner, the person who wants to have the marriage declared invalid, he or she is the one who carries the burden. He has the burden. Okay, let's continue our review. Again, this is very briefly from Canon Law 2. And this would be, if you're looking at Woodall, at 388. And what we want to talk about are the various defects of consent. We've just said how important consent is. We absolutely must have consent, or we do not have a marriage. So we're going to, if someone wants the marriage declared null, we're going to look and say, was there a defect of consent? Was there something that prevented consent from properly coming into being? And we've got several possibilities for what could be wrong. So I'm going to try to show you this, if I can, in my notes, some of the problems of defect of consent. Okay, So you can see this. Let me try here. This might be easier. Okay. Here's our defects of consent. We start with Canon 1095. It's extremely important. Over 90% of marriage cases are under 1095, and there are 3 sections, and each one is important. Lack of due reason, lack of due discretion, and lack of due competence. We'll return to this, but first we need to talk more about 1095. Remember I said lessons 10, 11, and 12 are closely bound together. That's because we've got one lesson on each section of Canon 1095. As you know from Canon L1 and 2, we mostly have said it's not too important to know actual canon numbers. This is a real exception. Canon 1095, it is important to know not only by number, but even by section. So our first lesson, this lesson 10 that we're starting with, is some background on consent, but also it's on the first section of Canon 1095, lack of due reason. And then we're going to go into, today, we're going to go into section 2, lack of due discretion. That is the most common ground for nullity. Extremely important. That's lesson 11. And then lesson 12 will be lack of due competence. And these things may sound similar. That's one of the challenges. If they sound similar to you, you're correct. There does seem to be some overlap. So the reason we say that these 3 lessons, 10, 11, and 12, are closely linked together is because each one is on a different section of Canon 1095. So that's why we're kind of grouping these lessons together. And what we'll probably do in this first video is both lesson 10 and either all or most of lesson 11. But before we go on to that, let's look at our other defects of consent, even though we won't be talking about them nearly as much, but so you remember what they are. Okay, 1095, the ones we just talked about, and then ignorance is another one, and this is ignorance essentially of what marriage is. Error of the person and error of the quality of a person. That's where you've kind of essentially either married the wrong person or you married a person for a specific reason, and that quality that you married the person for, it doesn't actually exist in that person. Deceit, you've been deceived and have made a mistake, again, because of usually some key quality or key factor that could really be disturbing about a person that they may have concealed. Radical error, again, this is an error about marriage. Then simulation. Simulation is very important. Probably after Canon 1095 is the most important ground under consent. Simulation is where either one of the goods of marriage or all of the goods of marriage are excluded. So the goods of marriage, of course, are the bonum prolus, the good of children, the good of the sacrament, the bonum sacramentum, and the good of fidelity or unity, the bonum fide. So either if you exclude children, you want to be married but not have children, or you want to be married and not have an exclusive relationship, those things invalidate the marriage. You're excluding one of the 3 principal goods of marriage. If you are just lying entirely, you don't wish to be married at all, say it's a green card marriage, you're only kind of pretending to get married so the other person can obtain a green card or can obtain legal residency or something in the country or legal status, that would be total simulation. You don't really have any intention of being married, you just want it to look like you're married legally. Okay, so and then after simulation, conditional consent is another possible difficulty with a matrimonial consent. and force and grave fear, where someone has essentially threatened you or forced you into marrying another person. So those are our various defects of consent. They all probably sound somewhat familiar, and they've come up in our class this semester as well. By and large, though, we're very concerned with Canon 1095 because so many cases are handled under that. We also will try to, after Lesson 12, make at least some comments about simulation. Okay, let's talk now about incapacity in general. Canon 1095 is about incapacity. It's saying that the marriage may be declared null if one or both of the spouses were incapable of contracting marriage because of one of these three reasons. So that's what we're talking about. There's a real incapacity. Now, so Section 1 is called lack of due reason. This is someone who simply lacks sufficient use of reason, and we're going to talk about that. That's the subject of Lesson 10. We'll say more about that. Section 2 is lack of due discretion, or a grave lack of discretionary judgment. And we'll say a great deal about that. And then Section 3, lack of due competence, or what the canon says is persons who, because of a psychological reason, they're unable to fulfill the obligations of marriage. So we'll talk about all three of these areas. The third one we'll save till our next video. Okay, Section 1. Let's start with Section 1, since it comes first. Lack of due reason. This is someone who lacks sufficient use of reason, and we're going to say they cannot consent. That makes sense, right? They don't have the ability to reason, so we're going to say they don't have the ability to consent. Why might they lack the ability to reason? They may have a mental disability, and if they do, it would have to be a very severe one to say that they're totally incapable of marrying. Wren, our author Wren, on page 21 of his book, The Invalid Marriage, refers to what he calls a habitual disorder, such as schizophrenia, as the type of thing that would show that you lacked due reason. You lacked sufficient use of reason to marry. If this is what your ground of nullity is that you're asserting, you're going to need an expert. You can't just, an ordinary person without psychological training can't just diagnose schizophrenia. So if you're saying there's a habitual disorder, then an actual kind of mental, possible mental disease, then we're going to say that you'll probably need an expert. What are some other ways you could lack due reason? One could be alcohol use. You may have been drunk at the wedding. It would have to be extremely drunk, probably, not just tipsy, but you were really so drunk you didn't know what was going on. Well, you don't have the use of reason in that case. The same with drug use, and the same with a head injury. You may have been in an accident and had a head injury where either you lost the use of reason, hopefully only temporarily, but you don't always know, or you may have good and bad days. So you may be fine some days, but other days really struggle. John Paul in 1987 gave an address to the Roman Rota, and he kind of cautioned about Canon 1095. In some ways, 1095 can be somewhat controversial. He said we have to be careful, make sure that if we have an expert, that they have an adequate anthropology. If there's someone who would consider everybody incapable of consenting to marriage permanently, somebody like that, they don't really believe in marriage in the the true sense of it. So we'd have to be sure that it's someone who has a proper anthropology before uh, asking them to be an expert in a marriage case. Um, okay, Hewells has a section in 258, 259 where he talks about what this idea of sufficient use of reason means. And here's what he says. The use of reason required for marriage is not the simple use of reason that the law presumes is attained by age 7, but sufficient use of reason to understand that marriage is a community of conjugal life for the good of the spouses and the the generation and upbringing of children. So there he's saying that this reason, the use of reason, it has to be enough, not not just to be able to do a basic word problem on a test or something, but enough reason to really understand what marriage is and to understand the importance of it. Um, okay, this section, by the way, said all three sections of Canon 1095 are important. Section 2 is the most common. Section 1 is not as common of a ground for nullity as sections 2 and 3, especially 2, happen to be. And the reason is probably pretty clear. There's not that many people who lack the use of reason and still get married. Either they or their family would realize usually that they were unable to marry, and this might be addressed in marriage preparation. So although we want to deal with all three sections, Section 1 is not nearly as common of a ground for nullity as 2 and 3 are, but they do happen. We do have these, again, cases like schizophrenia, but then also more temporary causes like drug or alcohol use. Okay, well, that's the end of Lesson 10, because remember, Lesson 10 is on lack of due reason, and it's not nearly as much to say about due reason as about the other two, just because there aren't as many cases, and it's pretty clear to us what it means to lack due reason. So let's move on to Section 2, lack of due discretion. And here a marriage is um, considered null because one or both of the spouses uh, suffers from a grave lack of discretion concerning matrimonial rights and obligations. Now, this incapacity is uh, not only about intellectual ability. So it's not just that. So somebody could be a very smart person, but they still could lack this due discretion that we're talking about with Section 2. Lack of due discretion involves the will as well as the intellect. And specifically, it affects the ability of the person to make a mature evaluation and to make a free choice. So it's not, so you could even have somebody who's involved in very complex work, a rocket scientist or something, but in their personal life, they still could suffer from lack of due discretion if they have more of a problem in that area. As you can probably tell by the way we're speaking, it's hard to pin down exactly this ground for nullity. So we, in a sense, have to mull it over and talk about it enough so that we get sort of a sense of it. But even when we get a sense of it, you really need to keep specific cases in mind. Woodall refers to lack of due discretion as an evaluative or critical knowledge and awareness of the importance of what is being undertaken. So he's saying the person who lacks that ability to evaluate, that awareness of how important marriage is, that's someone who may qualify under Section 2. Their marriage may be null because of a lack of due discretion. Wren makes an interesting point on page 25 of his book. He says that, the more important a decision is, the greater discretion you need. So you need more freedom to marry than you do to enter into a contract, another type of contract. For instance, buying a car. Buying a car is a big commitment and it's important, but marriage much more so. So you need greater maturity, greater critical awareness, greater powers of evaluation to decide whether to enter into marriage than you do to decide whether to, whether to buy a car. Okay, and another key point is that we're not talking, we refer to this ground most of the time as LDD, lack of due discretion, but it's not just lack of due discretion in general, it's lack of due discretion specifically in this context of marriage. So what the canon says is it's lack of due discretion as to the essential rights and obligations of marriage. So again, the person may be a brilliant scientist or a brilliant politician and really be able to evaluate the problems in his or her own field, but when it comes to the rights and obligations of marriage, may have much less ability, much less critical awareness. When we say this, though, when we say that there's discretion lacking as to the essential rights and obligations of marriage, what are we talking about? Why don't we start with Augustine's three goods? Someone who doesn't realize the significance of those things, the bonum prolus, the bonum fide, the bonum sacramenti, and the good of the spouses, the bonum conjugum, so that someone who hasn't sufficiently appreciated the significance of having children or the impact on the life of the spouses, or the same with regard to fidelity or permanence of marriage, or the good of the spouses, the what is required for for truly giving oneself in marriage and accepting another person in marriage. Things involving truthfulness, the ability to show affection, the ability truly to appreciate the other spouse, etc. Things like that be included under the bonum conjugum. Let me mention a different canonist who we didn't read, but we've used him sometimes in other classes. His name is Jose Tomas Martin Degar, and he refers to this ground. Again, we're more walking around this ground than really defining it, because it's a very difficult thing to pin down. He refers to lack of due discretion as a lack of understanding and responsibility, and he says that it may result from grave immaturity. You often hear immaturity talked about in connection with lack of due discretion, and then when we remember that the discretion concerns rights and obligations of marriage, can see how maturity could really be an issue. Do we really have the maturity to appreciate the significance of fidelity, raising children, etc.? John Paul, in his 1987 allocution to the Rota, which we just mentioned a moment ago, he said that we need to keep in mind there's a real fear that by associating lack of due discretion with something like grave immaturity, that we might open the gates too wide for declaring virtually any marriage null, and we don't want to do that. And John Paul says that, but just the fact that a marriage failed, that's not enough to show that it was null. We really have to show that there was a real incapacity. Remember, that's how the canon starts. Someone who qualifies under one of these provisions, they have an incapacity to exchange consent because of a grave lack of due discretion concerning the rights and obligations of marriage. So John Paul's emphasizing that we're not just talking about difficulties or even very significant difficulties, but a real incapacity to consent. If you remember from Woodall in Canon Law 2, he gives a number of factors that might come into play and they might suggest a lack of due discretion. Again, notice the language you're using. They suggest, they might indicate. It's not any one factor necessarily that proves that there's a lack of due discretion, but often it's a whole pattern in someone's life. But here's some things to watch for that Woodall talks about. Some behavior that might be inappropriate to the person's age, and he mentions drunkenness, drug abuse, squandering money, inability to hold down a job because of irresponsibility or aggressive or criminal behavior. Then he goes on further and he discusses more specific factual situations that might indicate a person's lack of due discretion regarding rights and obligations of marriage. One is a pattern of entering and leaving sexual relationships, and the difficulty that Woodall mentions there is a possible inadequate appreciation of fidelity. Also, a habit of intense commitments, but without persevering in those commitments. And here he says that might indicate a lack of appreciation for permanence in marriage. Self-centeredness is another thing to watch out for. Lack of openness to children, and entering or leaving entering marriage with little or no reflection would be another thing to say, boy, who would do this? Why would this person got married after only knowing this person such a short time? That seems to indicate that something's wrong there. Woodall, here at 391, also talks about the timing of consent. That might indicate something that would tell us something about whether the spouses were truly acting with freedom. Did the spouses marry in a hurry? Were they under pressure, for example, because of pregnancy? Keep in mind, although pregnancy could bring a lot of pressure to marriage, and it could impact one's discretion, just the fact that there was pregnancy doesn't automatically mean that the marriage is invalid, but again, it's a factor that will have to be looked at and taken into account. Also, arranged marriages, Woodall talks about. They're not necessarily invalid, but they require special care. You have to look and say, yes, the marriage was arranged by the families of the spouses, but are the spouses consenting to this? Are they agreeing with this and accepting the other person? Okay, so our various authors, such as Hewells, make this point that we're considering all these different factors, but no one of these things, say a pregnancy, say habit of drunkenness, no one of these things establishes automatically that we have a lack of due discretion case. Rather, we're kind of looking at a whole pattern. And here's what Hewells says at 260 for the Pastoral Companion. None of these factors in themselves is invalidating, but they can be indicators of an underlying psychic disorder, a transitory disturbance, or grave emotional immaturity. So we're kind of looking at these behaviors and asking, do they possibly indicate some problem? Okay. Another issue that sometimes comes up is a very unhappy life with one's parents. Was one's upbringing or life with parents so unhappy that they may marry with little reflection just to get out of the house and to get on to a different scenario, a different living situation. Also, a brief courtship sometimes, again, can indicate a marrying in haste or lack of sufficient reflection and pressure. Any type of pressure, but especially maybe pressure from the outside, pressure from one's family, or the type of pressure we talked about with pregnancy. That again, they might be indicators of the presence of lack of due discretion. Is an expert necessary in one of these cases? Now, we said in a Section 1 case, if we're talking about something like schizophrenia, then we would need an expert. In Section 2, you might or might not. It's certainly somewhat common to have an expert, but it really depends on the what the facts are that seem to indicate a possible lack of due discretion. Is it an actual psychological disorder? If it is, then you certainly would want to have an expert. Okay. Wren at 33 through 35 talks about retardation, and he talks about different IQ levels and which levels are considered still possible to consent to marriage. For instance, he says an IQ below 80 is usually considered insufficient to marry. So we might be able to have a judgment based on IQ. Again, at least in part. We don't want to paint with too broad of a brush here. Wren also mentions intoxication at 40 to 42, and he says that drunkenness does not necessarily invalidate the marriage, but you might have to look at was there consent exchanged previous to the marriage ceremony, and again, how drunk was the person. And finally, at 43, in the Wren book, he talks about pressured consent, where some pressure, usually from family members, might come into play in influencing one or both spouses to get married. Okay, that brings us to the end of lesson 11. So we've done 10 and 11 now in this video. We may say a little bit more about 11 in our next video, but we primarily will cover lesson 12. And then we may, as I say, talk a bit more about some of the other defects of consent, especially simulation, which also was quite important. Thank you very much.